this session is being recorded, so you'll have the benefit of the recording after the session today, and also Bella and Emily have kindly agreed to share a copy of the PDF slides. So no need to be scribbling down the case names as we go. You can just listen and consider whether you've got any questions to raise of the speakers. So my name's Roisin. I'm a solicitor at Roydsworthy King in the PI department. But I'm also on committee with Bristol Law Society, and I helped put together some of these events. So Old Square Chambers have very kindly agreed to run this clinical negligence case law update for us. And we're joined by Bella Webb, who's head of the Clin Neg group at Old Square Chambers. Bella specialises in complex, high-value Clin Neg and PI work, and she also undertakes medical regulatory work. And we've also got Emily Slocum, who accepts instructions in the fields of PI, Clin Neg, COP, inquests, and inquiries. So very broad experience, but lots of really good experience for a case law update today. If we do have any questions throughout the session, please just pop them in the Q&A box. I'm going to be monitoring that and then fielding the questions to Bella and Emily at the end. And if you have any issues with hearing the speakers or anything like that, you can also pop that in the chat box. So just have a quick look. Yeah, we've got around 50 of us now, so I'd quite like to start the session. Bella, shall I hand over to you?
Yes, thank you very much. Thank you to everyone for joining us today. As you know, we're here to talk about clinical negligence case law update for the past year, and I'm going to be dealing with the first half of the slides. Emily will deal with the second half. And these talks are always a bit tricky because, of course, everybody will pick differently. But these, of course, are our pick of the pops, as it were. So let's kick off with slide number 1. Let's see if I can get this changed. Right. Secondary victims. There have, of course, been a rash of secondary victim cases over the last couple of years, sadly, all of which have been unhelpful for claimants, and that's sad depending upon which side, of course, you're representing. But the first of the cases that I want to talk about today is King against Royal United Hospitals Bath NHS Foundation Trust. And this was a sad case where the claimant was a well-known actor. He'd appeared in a series called The Tudors and Mad Men, some of you may have seen. And his claim was one for damages as a secondary victim following the death of his son. And his claim was approaching something like £10 million because essentially he said that the events had meant that him and his wife couldn't move to Los Angeles to allow him to be part of the blockbuster Dunkirk that was due to be filming there. Essentially, his wife had noticed that there was a dip in the baby's heartbeat. She'd been assessed by a midwife. The baby was overdue at the time. And the decision was taken to postpone the caesarean section until the next morning. Long story short, baby is born by caesarean section, taken to NICU. And the doctors said that he was alive, but and they might, quote, still lose him. And essentially, the case hinged upon those words and the timing of conversations that took place between Dad and the medics in relation to the condition of the baby boy. And sadly, he died 5 days later. Liability for the death was admitted, and the claim for bereavement damages and for the baby, who was called Benjamin, his mum, as a primary victim, had been settled earlier. So the case dealt with the issue of secondary victims and when they could claim. Now, critically, this case was not about the delay between birth and death, because it was claimed and supported by medical evidence that the claimant had suffered post-traumatic stress disorder caused by seeing his critically ill son on his first visit to NICU after his birth. So in that sense, the King case is different to the three that follow that I'm going to talk about after this one. For the claimant to recover damages as a secondary victim, we all no doubt recall the Alcock criteria, known then as control mechanisms. They've been called various different things since, and those were recapped in this case. But just so we can recap them, there has to be a close tie of love and affection between the claimant and the person that's been killed, injured or imperilled. Secondly, the claimant has to be close to the incident in time and space. Thirdly, the claimant has to have actually perceived the incident rather than hearing about it from a third person. And fourthly, it has to be induced by a sudden shocking event, physical proximity between the event and the claimant's perception of it. Now, in this case, it was agreed the first three of those control mechanisms applied. And what the court were concerned with is whether or not this claimant had suffered a sudden and unexpected shock which amounted to a horrifying event. Case law has interpreted that in different ways over time, but critically, what is needed is something more than a shocking or horrifying event in ordinary speech. And the court noted the case of Ward and Leeds Teaching Hospitals, NHS Trust in 2004, where it was noted, for example, that the death of a loved one in hospital is not generally a horrifying event, although it's horrific to witness, unless there is something wholly exceptional about it, which is such as to shock or horrify. And that was the issue in this case. Now, on the facts, the court considered that the claimant was prepared for all of the machinery that he'd see. He had a conversation with the doctors before he saw his son, and that was part of the critical findings of fact that were made in this case, and required the court to ascertain whose version of events was preferred as to whether that conversation took place before or after the visit to NICU. And equally, the court accepted that once he did see his son, that there were no signs of physical distress. There were lots of people around, as you might expect, but his son essentially appeared as though he was sleeping without any signs of distress. And ultimately, the conclusion reached by the court was that that was not an objectively shocking and horrifying event within the Alcock sense, and as such, the claim failed on liability. Two other points of interest arise from that case, and they're noted on the slide, but I've already alluded to the fact that there was a dispute of fact as to when the conversations took place with the various doctors, and as a result, quite what this claimant was prepared to see and was aware of before he saw his son in the critical care unit. And essentially, the doctor's evidence was preferred on important events, including the chronology. And that was even though many of the notes weren't written contemporaneously, they were written retrospectively, and some of the authors weren't called to give evidence. We're going to talk a little bit later on in this talk about recollections and records, but what this case as well highlights is the importance of logical and consistent evidence. The court will look at records and look at people's recollections by way of forensic analysis, what makes most sense, how the records appear in the context of the overall evidence, and it goes to highlight the importance of that. The second point that is separate somewhat to the key issues within the case, but is important to remind us of, it is the criticism that occurred of the expert that was called in relation to the claimant's lost earning potential. Because although the claimant here lost on liability, the judge went on to make findings about quantum in case the case went on to appeal. And as far as I'm aware, there is no appeal in this case. And a lot of that was concerned with the loss of chance in respect of the significant earnings potential had the claimant moved to Los Angeles and got a role on the Dunkirk production, and also whether that would have enhanced his earning potential thereafter. And the criticism of the claimant's expert was that she had in many respects strayed outside of her expertise, and in some of the worst instances had engaged in advocacy on the claimant's behalf. And as an example of one of the issues that was picked out by the court was that there was a reluctance by this expert to accept the agreed joint evidence of the psychiatric experts as to the impact and duration of post-traumatic symptoms. And essentially, the judge said that that was perhaps because she was more used to the American system, this being her first experience of the trial process in the UK. But what it does is to serve as an important reminder to those engaged in this type of litigation of the need for the independence of experts, and to make sure that they stick to the areas of their expertise and don't go too far in support of the party for whom their report is relied upon. Final point to note on this one is that the judge reiterated that there was a need to separate out the post-traumatic stress disorder in this case and the natural grief reaction arising from the baby's death, which was not here part of the claim. And that's an important one because it turns upon the specifics of this case, that the injury was said to arise from witnessing the baby's condition immediately after his birth, and not the death that was some days further down the line. And that itself caused some difficulty when it came to assessing the likely quantum if liability had been established. And it's a point to bear in mind when one is considering secondary victim cases, and to look at the particular point in time where the injury is sustained and what it relates to. Okay, moving on from that then, we come to the trio, I like to call them the three Ps, Paul, Palmer, and Purchase. And these three, of course, were dealt with separately and all had, certainly Paul was one that was on appeal previously, but have since in the past year been considered as a joint appeal by the Court of Appeal. And all of these cases, unlike the King case that we just looked at, dealt with the issue of a delay between the negligent event of the act or omission, the advice that was given or not given, and the death. And in all of these cases, it was witnessing the death of the injured party that was said to have given rise to the psychological injury and the nervous shock. And so what we're talking about here is criteria 2 of the Alcock control mechanisms. Paul and Palmer were the claimant had been successful at first instance, and in Purchase the defendant had been successful. But essentially the Court of Appeal that was made up here of the Master of the Rolls, Sir Geoffrey Voss, Lord Justice Underhill and Lady Justice Nicola Davis, so a fairly heavyweight panel, was that all of the claims had to be dismissed. The main takeaway point from this, before we look at the circumstances of these cases in brief detail, is that the matter is not going to rest there. Permission was given to appeal to the Supreme Court because this was considered to be a matter of considerable interest, and it is highly likely to progress there. So we still need to watch this space, as it were. But just having a look at the individual circumstances very briefly, the Paul and Royal Wolverhampton NHS Trust case was about a negligent failure to diagnose heart disease. And in this case, the deceased had a fatal heart attack 14 months after the breach of duty, and his young daughters sadly witnessed his death and the attempts to bring him round, which ultimately were unsuccessful. Notably, in this case, perhaps unlike some of the others, the death was the first manifestation of injury arising from the negligence that was claimed. There hadn't been any other episodes of ill health in those 14 months in between. Master Cook initially struck out the claim on the basis of Taylor and Novo and Taylor and Somerset. Taylor and Novo being a personal injury accident case rather than a clinical negligence case. But Justice Chamberlain allowed the appeal against strikeout. The question was, of course, whether the heart attack would be the relevant event, despite it coming 14 months after the breach of duty. And Mr. Justice Chamberlain had considered that it could, upon the basis, first of all, that the authorities didn't require the event to be synchronous with the breach of duty, that it made no difference whether the breach arose from an act or an omission, and ultimately the scene of the tort was interpreted as being the scene of death because that was when the cause of action was said to be complete. So it was a neat little way of getting around the previous authorities, or so it was thought at the time. And on that basis, Taylor and Novo, Taylor and Somerset were distinguished. It was regarded as a case of a single event at which the claimants were present. Palmer was another traumatic case, as all of these are. Claimant's daughter had collapsed and died about 5 to 7 months after investigations, which had negligently not led to a diagnosis, and ultimately her parents had witnessed her, I think it says on the slides, her death. It's actually her body when she was dead. She ultimately had pulmonary veno-occlusive disease, and she'd had episodes where she appeared pale and breathless beforehand. Now, the case was not struck out by Master Cook, funnily enough, after the Paul case, relying on the appeal in Paul. And it was said that the deceased had sustained actionable injury symptoms during the months which led to her death. And Master Cook said that the final episode was a shocking event, which was the consequence of the defendant's breach of duty, and so strikeout wasn't appropriate. Purchase, then, just to complete the trio, claimant visited the GP with her daughter. There was a failure to diagnose that the daughter was suffering from pneumonia. And 2 days later, daughter dies, the claimant discovers her body. And this was, reading the facts of this case, particularly traumatic. There was an attempted resuscitation, which, without going into details because of the aspiration, was particularly unpleasant. There was subsequent discovery of a phone call from the daughter when parents were out, which was essentially her dying breaths during the phone call that had been missed. So it was highly traumatic in the circumstances. And the court in that case, District Judge Lum, applied Taylor and Novo and said that on that basis the claim couldn't succeed because death was separated from the negligent act. And it was the negligent act, the accident, that was the relevant shocking event, such as to establish proximity. And so, having only discovered the deceased body, there was no relevant event upon which to found the claim. So that's the background to those cases. Court of Appeal then had to consider these conjoined appeals. And ultimately, the defendants' appeals in Paul and Palmer, as I've said, were allowed. Claimant's appeal in Purchase was dismissed. The way that the claimants went about trying to argue the points before the Court of Appeal was slightly different as between the three. in Paul, or rather the claimant's team in Paul, argued that the relevant event for liability to be a victim, a secondary victim, had to be a single event that was the damage that it was the duty of the defendant to protect the primary victim against when that damage first became manifest or evident. And it'll be apparent from the circumstances of Paul, as I've described it, that really had to be the way in which that case was put. In Paul, Mere and Purchase, the case was put in a somewhat different way because of the specific circumstances of those cases. And the tack taken was to say that any horrific event caused by breach of duty to the primary victim was damage that was sufficient or ought to be sufficient to create legal proximity, whether it was manifest earlier or not in terms of damage. Master of the Rolls reviewed the 5 control mechanisms that we've already looked at in Alcock, albeit that he preferred to call them 5 elements because he felt that the terminology of control mechanisms was somewhat misleading. And what was considered to be the case was that even though those mechanisms had been established in an accident case, they were universally applicable. So it didn't matter that these were all cases of clinical negligence. The same provisions applied. Ultimately, the Court of Appeal felt bound by its own judgment in Taylor and Novo. And on that basis did not feel able to uphold the claimant's claims in all 3 of these cases. That having been said, the Master of the Rolls was very vocally sympathetic to the claimants in all 3 cases, and particularly perhaps to the judgment of Mr. Justice Chamberlain in the Paul case. And it was specifically said that there was no logical reason for those rules, but those were the rules as had been laid down by the courts. It is not to say that there have been no successful cases in the clinical arena, but they're few and far between. And in the judgment of the Court of Appeal, for example, it was noted that in the Walters case, which was a clinical negligence case in which liability was established, it was considered that that really was of a different genre because the horrific event and the negligence in that case were rightly considered to be part of a continuum of events rather than being removed in time and space. So that was where the court left matters by saying that, well, we're bound by our own decision. We have every sympathy. We don't think there's a logical basis, but really it's for the Supreme Court to consider and it's a matter of importance. So we'll have to await the Supreme Court judgment in due course, assuming that that appeal, as I think is safe to say, goes ahead. Interestingly, though, having said that there was no logical reason for the rules, the judgment does talk about how the approaches that were suggested by claimants' counsel in all 3 of these cases was overly nuanced and was said to create unprincipled and complex factual disputes as to either when damage was caused by the negligence that was occasioned or when it first manifested itself. And it also sought in many respects to argue about when a cause of action was complete, which was considered itself to be illogical, given that a secondary victim can claim even where there is no actual injury to the primary victim. And so it, in a sense, we may consider that there are logical arguments going both ways. So it'll be interesting to see how it is ultimately dealt with in due course further up the line. So we'll leave the secondary victims cases behind for the moment and go on to something entirely different, capacity. And this is the interesting case of Bell and Tavistock and Portman NHS Foundation Trust. It deals with gender issues and gender dysphoria, which is an increasing area which has implications across a wide range of areas, not just when one talks about capacity to consent in clinical negligence cases, but when one looks at transgender rights more generally, both in the educational and discriminatory law spheres too. In short, Tavistock ran, or still run as I understand it, the only gender dysphoria service for children in the country. And referrals were received from all sorts of different areas. And then rather later in time, patients could get an appointment with the Gender Identity Development Service, GIDS, and then about 16% of those who had appointments would then be referred onwards for treatment. And the case concerned a judicial review that was brought primarily by Miss Bell. She'd been treated with puberty blockers when she was 16. She had progressed to cross-hormone therapy and then ultimately to sex transition surgery, but had changed her mind after starting surgical intervention and had terminated treatment. And there was a challenge brought to the legitimacy of GIDS prescribing these puberty blockers to children under the age of 18. The divisional court made a declaration essentially that that was lawful, but they also gave the declaration in terms that in order to have Gillick competence, I'll come on to Gillick in a moment, a child had to understand, weigh and retain 8 specific pieces of information, which I'm not going to go into for today's purposes. But the controversial part of the divisional court's judgment was the guidance that it decided to give. And in short, that guidance suggested that it was highly unlikely that a child 13 years old or under, and doubtful that a child aged 14 or 15 years old would be competent to give consent to the administration of puberty blockers. And that even in the case of 16 and 17-year-olds, an application should basically be made to the court where there may be doubt as to the child's best interests. And as I understand it, following the divisional court's judgment, there was a complete drop-off of referrals being made to the GIDS for puberty blockers. In fact, no referrals were received after that case was heard. Court of Appeal comes in to review matters and finds that the declaration shouldn't have been granted. There was a refusal by the Court of Appeal to engage with allegations that there was also a breach of European Convention of Human Rights. But essentially, the crux of the judgment is that they were highly critical of the divisional court's approach. And I've set out on the slide some of the key issues that concerned the court in this case. First thing, the declaration was very different to the one that was sought and really turned expressions of opinion by the judges into statements of law when they weren't, and also where those statements of opinion were controversial and capable of changing over time. Secondly, that the effect of the guidance mandated court applications where they weren't in fact mandatory. Thirdly, the court wasn't in a position to generalise about minors' capacity to understand. And they cited the R. Burke case against the GMC, where it was noted that courts should be deferential to professional medics because they might not understand so much the implications for practice of guidance that they gave. And ultimately, Gillick was confirmed. And many of you will no doubt recall that that was a case concerning contraception, but gave rise to the principle that a child under 16 has got legal capacity to consent to medical examinations or treatment if that child has sufficient maturity and intelligence to understand the nature and the implications of the proposed treatment. And that's the key. And it was also for doctors and not for judges to decide on those capacity issues for consent to medical treatment in those under the age of 16. And equally, there was nothing at all about treatment in this area that took it outside of GILIC or outside of the usual rules of parental consent. So it's to be hoped that judgment will bring about a return in the referrals, inappropriate cases, of course, and will assist those dealing with these matters in practice. I'll whip through the last few very quickly because I'm mindful of time. Joinder then, this is the case of Paulie against White Cross Dental Care Limited. And it's one of a number of dental cases that have been causing controversy in recent times. I think Emily's also going to talk to you a little bit later on about the case of Hughes and Rutten, which is another dental case and was to some extent in issue here too. But this application in Paulie was dealt with before the appeal in Hughes and Rutten was heard. Essentially, claimant's a patient at the defendant's dental practice over a 6-year period, alleges negligent treatment by 4 different dentists. Claimant issues proceedings against the practice, but chooses not to do so against the individual dentist. And the allegations are those of vicarious liability and non-delegable duty, which are at the heart of the Hughes and Rutten case. And the court said, well, that was her choice. Bringing in the individual dentists would create potentially difficult issues about apportionment and causation, complexity in the management of the case. They may, for example, want different experts. There may be internal conflicts between them. And that's even if you got to the point where you could trace the individual dentist and where they had professional indemnity insurance in place. The oddity of this case was that the defendants applied to add the dentist under CPR Part 19 as a defendant, and the claimant objected to that. Note that the defendant did not seek to add the dentist as additional parties under Part 20, and that was something that the judgment also considered in some detail. County Court grants the application to join the dentist as defendants, and the Court of Appeal then allowed the appeal to say that they shouldn't do that. And what's interesting about this case is that the Court of Appeal considered that Part 19, the wording of it, was wide enough to allow the application. There was nothing legally within the terminology of the CPR that prevented that taking place. The point was that it would be wrong in principle to require a claimant to pursue a claim against a party to whom the claimant objected. And should any of you want to look at it in any further detail, it's really paragraphs 32 to 33 of the judgment. Interestingly, no evidence was presented to suggest that the individual dentist would not cooperate fully with the existing defendant, or in fact that they'd yet been approached to give witness evidence, which was a relevant consideration. But it was noted in particular that it wouldn't be fair to require a claimant to bring the claim against someone to whom they objected, especially where that would open them up to potential costs, liability in respect of that new defendant. And also, whereas here, they would face an immediate limitation defence because this was a case that was brought outside, where the application was outside of the limitation period. And one could imagine the difficulties the claimant would then have in trying to frame the Section 33 application to disapply the primary limitation period, where they've made a deliberate choice not to bring in those dentists in the first place. It should be noted that that doesn't apply in group litigation claims, and the court left open the propriety of taking this course in suitable cases. and one wonders what those might be, but it's not a complete block to the idea that this could ever happen. Final two cases that I want to look at before I pass you on to Emily are about records and recollections. And this is the cases of Malik and St George's University Hospital, NHS Foundation Trust, and HTR against Nottingham University Hospitals, NHS Trust. So I think my slides have just stuck. See if Emily can, thank you. I think Emily's just kindly moved it on for me. So dealing with the Malik case, but I should say that both of these relate to the fairly common scenario where the medical records don't completely match the claimant's version of events. And what the courts do in these cases reiterate that is start with the contemporaneous records and analyse them in the context in which they were produced and cross-reference them with all other sources of evidence. I'm not going to go through the facts of either case. They're there for you to read in short. But the key issue in the Malik case was the extent to which the claimant had complained in his outpatient clinic appointment of intercostal pain. So to what extent had he deteriorated since his initial emergency surgery, and what was he complaining of? And if he was complaining of intercostal pain, it was reasonable to offer him revision surgery. Sadly, that revision surgery left him here with incomplete paraparesis. Judge analysed the contemporaneous medical records produced by the GP, and an assessment report that had been prepared to assess entitlement to PIP. And ultimately, the judge concluded that even giving the claimant considerable latitude, he couldn't be convinced of his reliability as a witness. In large part, that came down to issues about discrepancies between evidence given at trial and the witness statements, inconsistency between the claimant's evidence and that of other witnesses, and reasonable inferences to be drawn from the medical records, as well as the general demeanour of the witnesses. But apart from acting as a helpful reminder, somewhat separately, that Bolam does still apply in the context of informed consent subsequent to Montgomery, when one's considering the reasonableness of alternative variants or alternative treatments. It is a case that also gave rise to some stark warnings in relation to note keeping. So whilst the doctors' evidence was preferred to that of the claimant, the surgeon here had a practice of dictating letters to the patient's general practitioner immediately after outpatient consultations, and didn't keep handwritten or typed contemporaneous notes of the appointments. Now, frankly, I've seen this time and time again, and I'm told that it's common practice. But the judge's concern about that and comments that he was taken aback by that practice, which seemed to the judge to be fraught with risk, it is a salutary reminder to medics of the risks of taking that course of action. It's also a warning to anybody taking part in litigation of the importance of witness evidence being consistent, and to claimants the importance of signing consent forms, having read them, because not reading them will not absolve you of responsibility, generally speaking, for the information given in that consent form. Finally, the HTR and Nottingham University Hospitals case. It was a case which turned wholly upon factual issues, whether or not the mum in this case, who gave birth to her child 4 days after the relevant clinic appointment, had mentioned reduced fetal movement at that appointment. And ultimately the baby was born subsequently in a poor condition. Mum had a clear recollection of reporting and relied upon the fact that an ultrasound was undertaken by this particular doctor to reassure her. And the defendant's case was twofold. There wasn't a report of reduced fetal movements because there was no record of it. And in fact, the record said that there were active fetal movements. And secondly, this doctor said that she did not and never had performed ultrasound examinations. And perhaps a critical turning point in this case was the fact that Mr. Justice Cotter considered that there was a serious question over the doctor's reliability because there was a discrepancy between her evidence at trial and her statement as to whether she undertook ultrasound scans or had ever done so. And ultimately, the quote is there on the slide for you. It was considered that that was seriously misleading, and what it meant was that where her evidence was not corroborated by records or other witnesses, it had in all respects to be considered with caution. Paragraphs 79 to 85 of the judgment are very helpful and should really be considered in full. But what this case gave rise to were, again, the important considerations. One shouldn't assume that contemporaneous records trump other evidence. It's got to be viewed in context, and it's got to be reliable as a source of evidence, and also the importance of ensuring that witness statements and party 18 replies are accurate, because that can be your downfall. And on that note, I'll hand over to Emily to take you through the rest of the cases. Thank you.
Thank you, Bella. They were all really interesting cases. Next, moving on to medical examinations. So dealing first with this case here, the claim was brought on behalf of a child who had suffered a serious brain injury. The claimant had brought the claim on the basis that it had been caused by hypoglycemia following birth, in which it was alleged that the defendant had failed to treat the hypoglycemia. There was no dispute that the claimant had suffered hypoglycemia. The issue was whether that was the cause of the brain injury. Before filing the defence, the defendant had applied for an order requiring the claimant and his parents to provide blood samples for genetic testing to find out if there was an alternative cause of the brain injury. Importantly, in this case, there had been an expert who provided evidence that there was a 20 to 25% chance of the proposed testing identifying a causal mutation for the claimant's injuries. This was not a case where the defendant had a positive view that the symptoms fitted a genetic cause, or that there was an unknown but likely genetic cause. It was just an investigation exercise. The court considered the two-stage test in Laycock, which is set out on the slide, and then went on to consider it not appropriate to order a child and his parents to provide blood samples for genetic testing in order to assist the defendant. It was said that the fact that the effect of the testing would be significant outweighed the potential benefit of the trust in providing indicative of it potentially indicating serious health consequences for the claimant or his parents, which were not relevant to causation. This could, for example, have been a predisposition to cancer, not relevant to the case, but of which may have come to light. It was felt that knowing that the test had been done might have profound implications either way if the claimant and parents wanted to know or didn't want to know the outcome. It might raise questions of whether they'd missed something that could have been avoided, and it was found that this was too great an adverse impact for the court to allow this testing to be done. The court further commented in this case that the lack of testing did not prevent causation being run by the defendant. It didn't absolve them from having a case. It just removed one element of their case. And therefore, in that case, the medical examination and the testing was not allowed, as it was considered to not be in the best interests of the case. Moving on fairly quickly, just due to time, next to breach and scope of duty of care, and there's two cases here that we will consider. The first I'll consider is Meadows, a case in which genetic testing was used. In this case, a mother appealed against the decision that a respondent doctor was not liable for costs associated with her son's autism. In 2006, the mother had sought advice in view to establish whether or not she carried the haemophilia gene. Following blood tests, the doctor gave the mother the impression that any child she may conceive would not have the gene. The mother went on to become pregnant, and shortly after her birth of her son was diagnosed with haemophilia and autism, but importantly, the autism was not related. The mother was referred for genetic testing, which revealed that had the original test been done correctly, this would have been identified. And the mother said that the testing would have shown her son would have been affected, and she would therefore have terminated the pregnancy. And on that basis, she says that both the autism and the haemophilia related costs should be paid for. It was admitted by the doctor that she was liable to compensate for the additional costs related with the haemophilia gene, but denied there was any responsibility for those costs related with autism. The High Court found the doctor liable for both elements of costs, but the Court of Appeal applied the scope of duty test as set out in South Africa Assets Management Corporation and found the doctor only to be liable for the costs associated with the haemophilia gene. The test is set out in terms of what 6 questions are to be considered there. And the mother submitted that this test didn't apply to clinical negligence claims or that an exception should be created, but it was disagreed with and said that the test was slightly broader than that in this case. The question was not whether the mother would have behaved differently if the advice provided by the defendant had been correct. Rather, it's counterfactual and assumes that the claimant would have behaved as she did in fact behave, and asks whether, if the advice had been correct, the claimant's actions would have resulted in the same loss. In this case, where the medical practitioner had not undertaken responsibility for the progression of the pregnancy and had undertaken only to provide information or advice in relation to risk of a pregnancy or the risk of an unforeseeable unrelated disability which could occur in pregnancy, it would not be, as a general rule, within the scope of the clinician's duty of care. It was said that the purpose, in this case, of the advice or importance was of central importance as to the outcome that was achieved, and therefore it was the only costs related with the haemophilia that were recoverable. Looking at Paulie, which again deals with similar legal issues, it related to a claim brought by a claimant who was 52. He had been diagnosed with arterial fibrillation and was prescribed warfarin to reduce the risk of blood clots. The claimant had chest pains and an angiogram was needed. To reduce the risk of uncontrolled bleeding during the procedure, the claimant was advised to stop taking warfarin for 4 days prior to the procedure. The claimant was discharged on the same day of the procedure and was advised to wait 2 further days before commencing the warfarin again. The claimant recommenced the warfarin 2 days later as advised, but suffered a stroke the following day. The defendant denied breach of duty, stating it was established practice to cease warfarin up to 5 days prior to angiograms, but admitted that the warfarin should have been restarted no later than 1 day post-procedure. The defendant had a surgical policy, which was that the warfarin ceased 3 days prior to surgery and recommenced as soon as the patient was able to take oral fluids. The claimant contended that this should have been applied to the angiograms as well. The defendant's expert disagreed and said advice was given in line with established medical practice. The claimant sought for an adverse inference to be drawn in line with the case of Wininski from a failure to call evidence from the authors of the guidance relating to surgery and those with clinical responsibility for the treatment. In considering whether that case applied, it was said that guidelines had no application to angiograms as they related to surgery, and those treating were not in breach of duty by failing to apply those surgical guidelines to this procedure. Further, the expert evidence provided no basis to find that the 3-day omission of warfarin would have been better practice than 5 or 4 days, and the trust had not breached its duty in care in advising the claimant to stop the warfarin for 4 days before the procedure. It's considered there was a body of reasonable, competent medical practitioners who would have deferred the restarting until the day after the procedure, and the trust would not have been in breach of duty of care had the warfarin been restarted one day earlier than in fact it was. Even if the omission of warfarin was more than 3 days, constituted a breach of duty, the claimant would have suffered a stroke in any event it was considered. A stroke is an indivisible injury. It either happened or it did not, and the size and severity was unaffected by the dose of warfarin. A claim for material contribution had to fail on the basis that modified test of causation did not apply where there was a single tortfeasor or an indivisible injury. The omission of warfarin had not made a material contribution to the occurrence of the claimant's stroke, and the claimant's experts struggled in evidence to find a material contribution if the breach of duty was confined to 1 day delay in restarting the warfarin. Moving really quickly on, just due to time, to vicarious liability and non-delegable duties, as Bella touched on earlier, the case of Hughes and Rutten. The courts in this case were required to consider a preliminary issue in relation to the dental negligence claim. The defendant had been the former owner of the dental practice, and the claim arose from NHS dental treatment provided to the claimant by 4 dentists who had been engaged at the dental practice. One of the dentists, referred to as K, was an employed assistant dentist, and the other 3 were self-employed associate dentists. The district judge had directed the trial of preliminary issues as to whether the defendant was liable for the alleged acts or omissions for the 4 dentists by virtue of vicarious liability or non-delegable duty of care. The defendant admitted that he was vicariously liable for the acts of K as they were under a contract of employment. In considering whether the defendant owed a non-delegable duty in relation to the other 3, the test in Woodland was considered and the principles were applied. I'm not going to read what sets out there in the slide, but that goes through the test in some detail there. A number of aspects as to the contracts were important in this case, and that was in relation to the record keeping, the payments of selection and training, and that was supported in this case by the contracts. In light of the conclusion linked to the test in Woodland, it was strictly not necessary to also consider vicarious liability in this case in the scope of associate dentists, but as the issue had been raised and had been fully argued at this point before the court, it was considered appropriate to therefore go on and give some judgment on it. The issue was whether the relationship between the defendant and the associate dentists were sufficiently akin to employment to make it fair and just to impose vicarious liability. The most significant question, it was felt, was whether the associate dentists were working as part of an independent business or an integral part of the defendant's business. The court concluded in this case that the associate dentists were providing dental treatment as an integral part of defendant's dental practice. The defendant appealed this decision, and as it says at the bottom, that was heard in the Court of Appeal on the 13th of January this year, and the judgment is awaited. But as it stands, it seems that there is a non-delegable duty and there is vicarious liability even for those self-employed dentists acting out of one practice. Moving on to limitation, there are 2 cases here within the slides. I will, I think, just deal with one due to time. So looking at Wilkins, the court considered first whether it was time barred before considering section 33. The claimant was diagnosed with bilateral knee arthritis, underwent knee replacement on both legs in November 18 and March 2019 respectively. He suffered pain and swelling in his left knee after the operation, as well as oozing and redness. He was treated for a suspected infection and went to his GP due to the pain in June 2009. In June 2012, he considered a first set of solicitors, referred to as HI, as he remained in pain. The attendance notes with those solicitors recorded that he had general concern about the treatment at the hospital, and the solicitors agreed initially to act on a CFA basis. The contemporary correspondence revealed that the main areas of concern were regarding the screws in the knee and thoughts that they may be too long. And an orthopaedic consultant was instructed to provide a report, and they gave not very favourable advice, and therefore the solicitors HI stopped acting in July 2013. The claimant's knee continued to deteriorate, and in June 2016, the claimant made the decision to amputate his left leg because of ongoing severe pain. Shortly before the amputation, the claimant instructed new solicitors, SS, and the defendant argued that the date of knowledge was made out in June 2009, when the claimant first attended his GP with pain. It was said that by June 2012, at the latest, the claimant had in broad terms ascribed the ongoing knee pain and treatment that he was receiving to the defendant, and therefore he was out of time. He was sufficiently troubled to consult the first set of solicitors. His appreciation of the nature of the claim in 2012 might have been different, but there was still an appreciation of a claim. It was agreed that therefore, or it wasn't agreed, it was found, that the claim was 4 years late on that basis, and therefore section 33 needed to be considered. It was considered in some detail within the judgment, and it was decided that against the background of the case, it was equitable in all the circumstances to disapply the time limit and to permit the claim to proceed. Whether or not a fair trial can take place was of utmost importance to consideration here, and it was said that the seriousness of the underlying claim was also relevant, along with the fact that the claimant was not culpable for the majority of the delay, it having come following unfavourable medico-legal advice. As I said, this case then does further go on to consider limitation and section 33, but I would just very quickly and finally deal with experts. This case was a defendant, in this case, the defendant was a cosmetic surgeon who undertook a closed rhinoplasty of the claimant. The claimant alleged that the defendant's technique caused a further deviation, leaving her with an S-shaped deviation to the nose, causing breathing difficulties and other issues and losses. The parties were in agreement that if the deviation was caused by surgery, then this represented negligent technique. The claimant contended that the deviation was caused by the surgery, whereas the defendant contended it predated. The court found for the defendant in this case, the primary reason being an assessment of the expert evidence. The claimant caused an aesthetic plastic surgeon, and the defendant called an honorary consultant in ENT and professor in rhinology. The court considered that whilst the aesthetic plastic surgeon had considerable expertise, they had no professional background in this specific surgery or in the anatomy of the nose, and this was different to the defendant's expert, who clearly had extensive expertise and practice in this area. The case, therefore, is a clear reminder of the necessity to obtain expert evidence from a person with the most specialist skills possible on the central issue, or risk being evidentially outmatched at trial, as the claimant was in this case. Thank you. I apologise, that was a bit of a whistle-stop tour through the second half there.
My fault for overrunning on the first.
I think that was fantastic, both of you. Thank you. Obviously, you've only overrun by a minute or two because you fitted so much in. So we've had a real whistle-stop tour there of the last 12 months of case law that you flagged as interesting for us. And I can see a lot of practice points in there that can be drawn out. So thank you very much for that. I've been keeping an eye on the Q&As, and I don't think we've had any come in, but if anybody has any questions now, do please sort of put your hand up or pop something in the Q&A box quickly. I think we're probably not going to have a vast amount of time to talk about questions, but here we go, we've got one. When will the slides and recording be sent? So generally, I might have to look to Claire to this one. We do need a few days to sort of put everything together and collate it. So perhaps if you allow us a week, Claire will tell me if that's too soon. But yes, as shortly as we can. Oh yeah, no, Claire thinks she can probably have those together by tomorrow lunchtime. So hopefully that's of benefit to you. You can see that we've got contact details for Old Square Chambers on the screen there. And obviously you've heard from Emily and Bella today. I'm sure they'd be happy for you to ask for them specifically with any inquiries you have. And in terms of future webinars with Bristol Law Society, please just do make sure that you're following us on social. So we do advertise all of our events on Twitter, LinkedIn, as well as our email to all of you. And we'll be continuing to advertise more events for the rest of 2022. So don't think we have any more questions. Bella and Emily, do you have any final closing remarks?
No, and to say thank you very much for having us come and talk to you today, and I hope everyone has found it useful.
Yeah.
Yes,
thank you very much, everyone.